Good afternoon, ladies and gentlemen. Welcome, coming out on this first nice day of July, I guess, right? Yeah. And so I see most of the faces are familiar. Those who haven't been here before, I'm John Gardella. I've been doing these talks for about 5 years. And I'm a retired high school teacher, taught AP, government and politics plus AP history. So that's my background. And I give these talks for the entertainment of the community and also to hopefully get people interested in the topic where they might do further, further research or reading on a topic. I've been doing a 4-part series on the institutions of government, and today is the 4th part, and it's on the judicial branch. Oh, my wife over here, Jana, is my projectionist, and as most of you know, she always baked cookies for our intermission, but we're not allowed to now. Hopefully soon. So our agenda today, and we always start with an essential question. Should federal judges and Supreme Court justices serve for life? So that's the first question. They have lifetime appointments. Should that be? And the second question is, should the Supreme Court decide cases based only on the language found in the Constitution? And we'll talk about those things and any questions or things you want to discuss at the end of the talk. Today I'm going to do a brief introduction and then look at the development of the federal courts, the structure of the federal courts, the jurisdiction of the federal courts, getting to court, the Supreme Court in action, the power of the federal courts, and the checks on the judicial power. And then we'll have our discussion. The Supreme Court building, of course, I'm sure many people have visited. It's right behind right behind Congress, the Congressional building. The reason I showed it is it really is a wonderful structure. And when you approach it, you really feel the strength and the importance of the Supreme Court. There was also a case involving the ADA, the Americans with Disabilities Act, and there was a famous photograph, and I guess it's a video as well, of a person who was part of the suit that was being discussed by the Supreme Court. The Supreme Court didn't have a handicap entrance, and so he actually crawled, dragged himself up the stairs to get into the Supreme Court. Okay. Our current justices of the Supreme Court, and there's several new ones, it's a fairly young court with the first row, second from the left, of course, is Justice Souter. And there's been a lot of talk. He's turning 83, I guess, this week or next week. And there's been a lot of talk on that he should retire so President Biden could nominate a new liberal justice. If you want to click to the next slide, Jan. Okay, so we have the current justices of the Supreme Court, those nominated by Republican presidents, you can see, and then the 3 democratically nominated presidents. So it's a 6-3 conservative majority. Clarence Thomas is considered to be the most conservative of the justices, followed by Samuel Alito. So it's an interesting mix. And John Roberts had become sort of even though he's the Chief Justice, it becomes sort of the swing vote, but now with 6-3, it's pretty one-sided. So, and yes, Mrs. Taylor, these are appointed for life. And a lot of them are very young. Amy Coney Barrett's only 49. She just turned 49. Okay, the introduction. So federal courts at every level make decisions that affect all of us. As the power of the federal government has grown, we looked at the executive branch, we looked at Congress, and we saw that the increasing power, especially of the executive branch over the years, So has the power of the courts. At one time, there was no government policies on things like the environment and welfare and abortion and gun control and civil rights. Now there's policies on all of these issues. And as they come before the courts basically through their rulings explain what these policies mean and sometimes reinterpret what the policies mean. And we'll look at that as we go along as well. One aspect of the power, and it's probably the most powerful part of the Supreme Court, is judicial review. It's the right of federal courts to declare laws of Congress and executive actions to be unconstitutional, okay? And it's really the most powerful part of the checks and balances that the Supreme Court has. The federal court's power of judicial review is widely accepted, but the method on how the review is conducted is controversial. So we'll look at that. So two competing views, and this goes to our essential question that I'd like to discuss at the end of my talk. The first is strict constructionist, and the belief is that when judges or justices decide a case, they should confine themselves to applying those rules that are stated in or clearly implied by the language of the Constitution. Okay, so it's sort of an orthodox approach. If it's in the Constitution, clearly then we can apply those rules. Today, Republicans and conservatives tend to favor this approach, but early in our history, the Jeffersonians, who were kind of the liberals of the day, who were concerned with the welfare of the common man, favored the approach because they were afraid of governmental overreach, the overreach of the national government. Now, the activist approach argues that judges should discover the general principles underlining the Constitution and its often vague language. It's written, more than 200 years ago. Finding some moral or economic philosophy and then applying them to modern circumstances. Okay, so an activist approach. Today, Democrats and liberals tend to favor this approach. But again, early in our history, the Federalists and the Hamiltonians who want to reserve power for the wealthy or the busy interests of men, as they called it, along the eastern seaboard, and wealthy landowners in the business class favored this approach because they believed only a strong government could provide stability, and that's what they were looking for. Okay. So the development of the federal courts. The founders' view. So the founders probably expected that there would be judicial review, and most people think that's they meant by it, though they didn't clearly state it in Article 3 of the Constitution. The traditional view of civil courts was that judges judged disputes between people who had direct dealings with each other. Okay? And then the court would decide which of the two parties was right and then supply relief to the injured party. And we'll take a look at what we mean by relief a little bit later. The traditional understanding was based on the belief that judges would find and apply existing law. The purpose of the court was not to learn what the judge believed, but what the law requires. Okay? The view that the judges interpret the law and do not make policy made it easier for the founders to justify the power of judicial review because they didn't think that the courts were going to be very involved in public affairs. They really saw more of a limited role of the courts. The development of the federal courts from the founders' view to the present level of activism and influence has been shaped by political, economic, and ideological forces from three historic periods. We're going to look at those three historic periods. So the first one is national supremacy and slavery, basically from 1789 to 1865. So during this time period, the main interest of the court was a question that was really left unresolved because they couldn't resolve it in the Constitutional Convention, and that was the nature of the relationship between the nation and the states, the various states. In other words, who was going to be more powerful. Under the leadership of the third Chief Justice, John Marshall, the answer was the national law in all instances was to dominate, and the states would have to give way. The Supreme Court had the power to decide what the Constitution meant. Now, you have to know a little bit about John Marshall. He was from Virginia. He went to William and Mary. He was an officer during the War for Independence, and he was at Valley Forge during that awful winter when the soldiers were starving. They didn't have, their clothing was inadequate, their supplies. And a lot of that reason was the Continental Congress, which was basically acting as the national government, couldn't get their act together, okay? They just wouldn't fund because there was no taxation ability or the Continental Congress had to ask the states for contributions, and a lot of them were not forthcoming. So he came out of there saying, we need a strong government that can be stable. Marbury versus Madison, which is going to establish judicial review of 1803, and it was a brilliant move by Marshall. He was a brilliant jurist. And it had to do with John Adams, who was a Federalist. And if you saw my talk, I don't know when it was, a year or so ago, on the two-party system, you'll know that there was the Federalists versus which was the Hamiltonians, versus the Jeffersonians, which were the Democratic Republicans. And so Marshall was a Federalist. He's going to be a Supreme Court justice. And John Adams was the outgoing president. He had been defeated by Thomas Jefferson. And he appointed a series of judges, and they're called the Midnight Judges, okay? Not to be confused with the great rock band that I was a member of for many years, okay? Right before he left office. So Jefferson comes in, and Madison is Jefferson's Secretary of State, who, under the law, was supposed to send out the commissions. Basically the letter stating you are a federal judge, you're hereby appointed a federal judge. Some of them were sent out, and some of them weren't. William Marbury didn't receive one. So he basically went to court and said, I was duly appointed, and I should receive my commission. Marshall, brilliant man, was in a conundrum, okay? Whichever way he moved, he was going to be in trouble. If he found it just up for Marbury, okay, then Jefferson and Madison could say, what are you going to do about it, Supreme Court? Okay? And they would lose their, any power that they had, okay? Now, if he just founded for Madison, and just give in, he wouldn't have influence as well. So what does he do? He says that the appointments were based on the Judiciary Act of 1789. It's unconstitutional. Okay, we're not going to go into that whole business. But what he did is he established judicial review, which made the Supreme Court very powerful. Okay, and it was a brilliant move because, one, it established the significance and the importance of the court, and it wasn't pushed to the side. So it's politically smart. McCulloch versus Maryland, 1819. The United States had established a bank, a national bank, Hamilton's big national bank, and it had been rechartered, and there was one in Baltimore. And Maryland didn't like it because it was competing with their state banks. So Maryland placed a tax on the national bank in Maryland, and to try to shut it. It was a heavy tax to try to destroy the bank. So, and McCulloch was the cashier for the federal government that was supposed to pay the tax. So it goes to court, and Marshall rules that the power to tax is the power to destroy, okay, he writes, and then also that the necessary, under the Constitution, which gives Congress the right to pass anything or do anything that's necessary and proper to carry out the function of the United States, is constitutional. So what this did is establish that the federal law is supreme over state law, okay? And then the third one I put up is Martin versus Hunter's lessee. It was 1816. And it was, and again, it's a very convoluted case. I'm not going to go into it at all. But what it did was it said that the Supreme Court was the Supreme Court of the land and could overrule decisions of state Supreme Courts. Okay. And so that's extending their power quite a bit. Okay. Federal power to regulate commerce. And we'll see and we know that the Commerce Clause gives Congress a tremendous amount of power. A lot of what they do, they base on the Commerce Clause. And the other is the slavery issue, and which we'll get to in a minute. So in Gibbons v. Ogden, that had to do with a monopoly that New York gave to, was it Foster? Anyways, a steamboat operator to operate a steamboat between New York and New Jersey, okay? So it went across state lines. And Gibbons and Ogden had been partners, and then they disagree, and they fall apart, and it goes to court. So basically, in this ruling in 1824, it gives Congress the power to enforce the Commerce Clause on interstate commerce. Okay. Now, interestingly enough, a lot of the court trials that will come up, or the decisions that come up, have to do with just intra-state, within states, but it could have an impact, and we'll look at when they decide that's okay or not in a little bit. The Marshall Court had significantly increased the power of the national government. The National Republican Party, which became the Whig Party, because they were mad at, they didn't like President Andrew Jackson, were not happy. But then Jackson, okay, he's a Democrat. He starts the Democratic Party, if you remember, if you were here from my executive branch talk. Doesn't like it either. Jackson kind of wants to do what Jackson wants to do. I mean, definitely, okay? He doesn't want bounds put on him. So he typically doesn't like the strong federal government, even though he's the head of it, okay? So John Marshall dies in 1835, and Jackson names Roger Taney of Maryland to be the Chief Justice. He had been a former Federalist, and he served as the U.S. Attorney General and Secretary of the Treasury under Jackson, and he was a strong states' rights advocate. And he had started to lead cases towards states' rights before the Dred Scott case comes to him in 1857. I'm sure everybody in this room has heard of Dred Scott, and who was the slave who had been moved by his master, who was a doctor, an army doctor, from a slave state into a non-slave state, and then the doctor went back to the slave state and said to Dred Scott, would you come continue to serve me? So Dred Scott voluntarily, with his new wife, comes to the slave state. The doctor dies. The wife inherits Dred Scott, but her brother is in charge of her estate. So the Dred Scott case is to determine whether or not Dred Scott was free or whether he was still a slave, okay? Now, people had high hopes for the Dred Scott case that it would be a legal remedy to the slavery issue, okay? There had not been a political remedy, because that was going to have to take place in Congress, And with our development, if you remember Congress, we have the House of Representatives based on population, but then each state has 2 senators. And so, and for a law to pass Congress, it has to go past both the House and the Senate. And the slave states, of course, were always able to block any movement on slavery. So anyway, he rules in 1857 on the slavery issue against Dred Scott. And he says, Negroes, and that's his word, not mine, were not citizens of the United States and could not become so. Part of an earlier compromise was called the Compromise of 1820, which the Southerners had agreed to, which was basically the Southern territories could expand slavery into the Southern territories, but not the Northern territories. Well, he said that Congress didn't have the right. The Missouri Compromise of 1820 was unconstitutional, okay? And so therefore, Congress did not have the right to pass a law limiting a state's ability or control over slavery. Okay, so we had the political issue block, way to solve the problem block. Now we have the legal way. Of course, what's left would be the Civil War, which appeared, that, okay, this is going to solve this issue once and for all. Really hasn't. There's still many things that come up that have, federalism issues, whether it's states' rights or the national rights. Okay. Government and the economy. Okay, so this is the second historic period we're going to look at. All right. During this period, between the Civil War and the mid-1930s, the Supreme Court has strong interest in protecting private property. The founders believed that property rights and political rights were closely linked, and the Marshall Court had strongly upheld contracts in his decisions. After the Civil War, of course, the economy expands tremendously, and we saw a lot of that expansion right in Massachusetts up in Lowell and Lawrence. These huge corporations are set up. And along with monopolies, Rockefeller, Carnegie, and all those fellows, okay? So these big corporations were dominating many industries. So the 14th Amendment in 1868 was passed. It's one of the Civil War amendments, which primarily had been adopted to protect African American citizenship rights against hostile states, okay? Now it was going to be used to protect private property of corporations from state government actions. And this is a quote from the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law. Okay? So the Supreme Court says corporations are people, basically. Okay? It's kind of similar to the Citizens United decision that was, in our recent history. So once that happened, these corporations started to bring suit against all these state regulations that had been put in place. And the court became crazy busy. All these cases flooded in because they became the arbiter of what regulation was permissible and what wasn't. In the first 75 years of the nation, only 2 federal laws had been ruled to be unconstitutional. In the next 71 federal laws were ruled unconstitutional, and roughly 13 of the 1,300 state laws to be ruled unconstitutional, 1,200 of those were ruled after 1871. So the court becomes much more active. Types of regulations ruled to be unconstitutional or constitutional. Okay, so the first is decisions blocking regulations of the states to protect private property. So injunctions against private labor strikes. So these companies would go and get an injunction against the labor union, okay, and to block it. Federal income tax, which had been put in during the Civil War in 1895, was ruled to be unconstitutional because it was a direct tax And it's not until the 16th Amendment where it's the Constitution has to be amended to allow for the income tax, which we're all really happy about. The limits on antitrust laws. So these big corporations, the states were bringing in, and the national government was bringing antitrust laws saying you can't have a trust, you can't have a monopoly. A trust is a complicated combination of businesses. Restrictions on interstate commerce commission to set railroad rates. These railroads had been built out in the Midwest and the West largely by using government funds, but then they had a monopoly. And the farmers that, of course, had farms in the area of these railroads could only ship their goods on one railroad, and they were setting these exorbitant prices. Prohibited the federal government from eliminating child labor. Okay, that's why we had child labor well into the 20th century. I think it was like 1927 or something. Prevented states from setting maximum work hours. In 184 cases between 1899 and 1937, the court struck down state laws for violating the 14th Amendment, usually by economic regulations, okay? State regulations on business were often upheld if they were, and this is the part to be ruled constitutional, if there was a strong public interest. And when we look at sort of the restrictions on the court later on, we'll remember strong public interest. These included railroad safety, anti-liquor laws, mine safety, workers' compensation, state regulations of fire insurance rates, and eventually state laws governing workers' hours and wages. So it originally that said the states couldn't regulate, but then when enough of the working class became voters and things, then all of a sudden it changes. The court was consistent with the 14th and 15th Amendment regarding African American rights, though. Okay, in a series of decisions, the court upheld segregation in schools and railroad cars, Plessy v. Ferguson in the 1890s, right? And permitted blacks to be excluded from voting in many states. A pregnant pause. Okay. Next. Government and political liberty. So this is the third of the three historic time periods. So after 1836, the Supreme Court stopped imposing serious restrictions on state and federal regulations of the economy, leaving it to the legislatures, the states and Congress. Between 1836 and 1974, the Supreme Court did not overturn a single law regulating business. It did overturn 36 congressional acts that violated personal political liberties, such as restrictions on freedom of speech, denied passports to communists, permitted the government to revoke a person's citizenship, withheld mail, restricted the availability of government benefits. Okay, so, and if you go back to my original, part one of this series, when we talked about the Constitutional Convention, the goal of the Constitution was to create a stable government, a strong government, but still protected personal liberties, okay, which is a real trick. And so this is applying to those types of situations. Basically, the protection of the minority, and I don't just mean racial or religious minorities, but the minority view as well. Between 1933 and 1936, the court opposed many of FDR, Franklin Delano Roosevelt's New Deal programs by a 5-4 margin. FDR responded by threatening to pack the court. Okay? Now, Congress was not going to go along with this, but it did put enough of a fear into at least one of the Supreme Court justices who had originally opposed what they called the welfare state of FDR's programs, the New Deal programs. And he started to support FDR's economic programs, which made all the difference, right? Several of the justices that were still there promptly retired, okay, allowing FDR, eventually he appointed 7 of the 9 justices, and which really expanded the court's interest in political liberty, but also eventually civil rights. Okay, the Warren Court. So we're up to 1953 to 1969. In 53, President Eisenhower appointed Earl Warren to be the 14th Chief Justice of the Supreme Court. And he was a California guy, he was a Republican, thought to be a conservative. But as he grew older with age, he started to become more liberal, okay? And he saw a connection between poverty and crime and levels of education and social conditions and standards of law enforcement, okay? Those things that we're still talking about today, all right? Earl Warren actually was recognizing in the 1950s. Activism rose to redefine the relationship between citizens and the government, especially to protect the rights and liberties of the citizens from government trespass, in other words, interference in our lives. Before 1937, conservatives sought protection from the government overreach, and after 1937, shifted to liberals that were seeking that. Landmark cases of the Warren Court: Brown v. Board of Education, okay, which basically, the schools were segregated, so it's a ruling against education. I think I've talked to Tina. I might do a series in the fall, let me digress here for a minute, on various constitutional amendments. And so I would get in, if people would you be interested in that? Sure. Yeah. Yes? I'm looking for some feedback here. Yeah, maybe? Okay. And so we go more in some of these cases. But in Brown v. Board of Education, they actually hired a sociologist from Harvard to show that, and it's a very moving case, but to show that segregating children, even if they had an equal school, separate but equal, okay, coming out of the Plessy v. Ferguson case in the 1890s, it still was unequal because the way it made the children feel, okay? And they showed that. And that was a unanimous decision. Reynolds versus Sims, 1964, the size of voting districts, which applied the principle of one person, one vote, okay, still coming up. This one blows my mind. Griswold v. Connecticut, 1965, the right for married couples to obtain birth control. Went to the Supreme Court in 1965, okay? Miranda v. Arizona, 66, Miranda warnings to inform a person who is being arrested of their rights. Loving versus Virginia, 1967, ruled that laws banning interracial marriage, violated the equal protection and due process clauses of the 14th Amendment. Of course, this is going to lead to same-sex marriages being constitutional. So the Warren Court, some people say it was a constitutional revolution in the liberal direction, okay, even though he had been a conservative. The revival of state sovereignty, okay, we're going to see the swing back. So when Chief Justice Warren Burger, who had followed Chief Justice Warren, I know there's two Warrens in there, who's appointed by President Nixon, President Ronald Reagan appointed William Rehnquist to be the Chief Justice. Okay, Rehnquist, who had served as Associate Justice to the court since Nixon had appointed Rehnquist as well in 1972. Nixon also appointed Sandra Day O'Connor, Antonin Scalia, and Anthony M. Kennedy, which is pretty interesting because both Sandra Day O'Connor, who was a conservative, she was out of Arizona, but what she came around to and started to really support women's rights and rights for an abortion, those types of rights. So she was a deciding vote, a swing vote quite often. And we're going to talk about her a little bit in a minute. Anthony Kennedy, okay, after Sandra Day O'Connor retired, becomes the swing vote. And he just retired, which was kind of too bad. Of course, Antonin Scalia was really a conservative, a real character. Is that me? A real character. Okay, at least we're not getting the feedback we used to get when I get blown off the stage, right? Who unfortunately passed away. They were all Reagan appointments. So in 1992, with the court led by William Rehnquist, there was a slow shift began, upholding state actions that challenged laws passed by Congress. Some have called it the Federalist Revolution as opposed to the Constitutional Revolution, the Federalist Revolution. Remember, federalism is the power to govern is split between the states, the various states, and the national government. So important cases of Rehnquist were New York versus United States, 1992. It had to do, states could refuse to store low-level radioactive waste. And you might say, well, that's a good idea. But then if nobody will store it, what are you going to do with it, right? And United States v. Lopez in 1995, Congress had passed a law outlawing gun possession within a certain distance of schools, on school property and within a certain distance. This young man, Lopez, had been arrested and convicted of it. The court overturns the case, fines for him, saying that the law outlawing guns near schools was unconstitutional. Okay, I'll come back to that in a minute. Prince versus United States, 1997, said that Congress could not force local police chiefs to conduct background checks before gun purchases. So there can't be a federal law that requires police departments to do background checks. And the United States v. Morrison in 2000 struck down parts of the Violence Against Women's Act of 1994 because it believed Congress had exceeded its power. Okay, so I'm seeing a lot of looks like, what? You know, well, what the two arguments were basically, in Lopez, for instance, the liberals were saying, well, if people have guns in school, therefore students will be afraid, there'll be more violence in the neighborhoods, students will be afraid to go to school. And therefore it hurts the economy, okay? And a similar argument was done for women. If women are afraid to go out in public and to their jobs and shopping and taking care of their children out, playgrounds and things, that'll hurt the economy. And what the conservatives said, and the way the court ruled, was, well, that may be, but if you allow Congress to pass laws on these issues, there's going to be no limit as to what Congress can pass a law on and base it on the Commerce Clause. So they put a sort of a ceiling, if you will, to the Commerce Clause. When Rehnquist dies in 2005, President George W. Bush appointed John Roberts to be the Chief Justice and conservative Samuel Alito to replace Sandra Day O'Connor. Now, Sandra Day O'Connor was furious with this, okay? Because she was still a very active judge, had, great mind. She was doing really good work on the court, but her husband was suffering from dementia of some type. And so she wanted to take care of her husband. So she went and talked to President Bush and said, if I resign, and obviously you'll be able to appoint me, please appoint a moderate, okay? I've been pretty moderate on the bench, and if you promise that you'll appoint a moderate, I'll resign. She resigned. He appointed Alito, who is not a moderate on the bench. So after President Trump's appointments, the court now has that 6-3 conservative majority, which I'd showed you at the beginning. Okay, structure of the federal courts. So the Supreme Court is the only federal court specifically mentioned in Article 3 of the Constitution, okay? In Article 3, it says Congress may create courts as needed, lower courts or inferior courts as needed, which of course they have done. So all other federal courts were created by Congress. A constitutional court is one exercising the powers, the judicial powers found in Article 3. Federal judges in constitutional courts are given constitutional protection. They may not be fired, so they serve for life or until they decide to retire. Okay, and of course many of them have gone really, really into old age. Or they could be removed by impeachment. We'll talk about that in a bit. The salaries may not be reduced while they're in office as well. Well, these protections were put in to take away political coercion or influence on them, so they could step back. And I guess, you know, you'd look at some of the decisions you made and say that's true. They went outside of their president's desires who had appointed them. District courts, okay? There are 94 district courts. These are the courts of original jurisdiction. These are trial courts, okay, with at least one in each state, in the District of Columbia and in the Commonwealth of Puerto Rico. We have 3 in Massachusetts, one in Springfield, one in Worcester, and in the Moakley building in Boston, which is that beautiful glass building on the harbor. Then there's the Circuit Court of Appeals, federal courts that only hear appeals, no trials, okay, from the district courts. So there are courts of appeals in 11 regions and circuits plus one in Washington, D.C., in the District of Columbia. Okay. Selecting judges. Party background makes a difference in how judges behave on the bench. There's been more than 80 studies that have shown a connection between liberalism and conservatism versus in how they react on the bench and who appointed them. However, ideology does not entirely determine behavior. Many other things shape court decisions. Of course, the facts of the case, prior rulings by the lower courts, arguments presented by lawyers. There's no reliable way to predict how a judge will rule in all matters. And presidents are often angered by actions of judicial appointments. Okay, so Nixon, of course, appointed Warren Burger, who wrote an opinion upholding school busing. Okay, Nixon was not a happy camper. Okay, Harry Blackmun, another Nixon appointment, wrote the opinion declaring the right of abortion is to be constitutionally protected in Roe v. Wade, okay, which was considered to be a real activist decision. And of course, John Roberts recently ruled in the Affordable Care Act with the liberals, which didn't make the conservatives happy at all. And he had been quite a conservative justice. So appointments of judges. The Constitution includes no specific requirements to be a Supreme Court justice. None. No age, no education, experience, nada, okay? Now, in reality, of course, in modern times, that there are a lot of things that you have to have done to become a Supreme Court justice. But as stated in the Constitution, federal judges, including district court judges, circuit court of appeals judges, and the Supreme Court justices are nominated by the President and confirmed by the U.S. Senate. Okay, this is going to Mrs. Taylor's question at the beginning. Traditionally, a 2/3 vote to confirm was required, changed to a 3/5 in 1975. Now, in 2013, okay, Democratic Senate Majority Leader Harry Reid used what became known as the nuclear option. I think we talked about this when we looked at Congress last month. But the nuclear option to require only a 51% vote to confirm a federal judge. And then in 2017, Republican Senate Majority Leader Mitch McConnell applied the 51% rule to Supreme Court justices, which of course made all the difference in the recent appointments. Now, the American Bar Association rates nominees. So a president has, they all develop these lists of people that they would nominate if the opportunity arises. And one of the places they look is the American Bar Association. The Federalist Society, okay, which is a conservative organization of lawyers and law professors that came about in the 1970s and it was part of that conservative movement that I've talked about a little bit before. The Koch brothers sponsored a lot of this. And what they did was they sponsored a lot of chairs in law schools and deans and things like that. And then gave scholarships to conservative-leaning college students to go to law schools. And they built up this huge organization of conservative lawyers, basically. And they have lists that the president, conservative presidents choose from of acceptable nominees. John Roberts is, well, actually all the Republican nominees came out of that list, okay? Not nominees. Conservative justices. Senatorial courtesy. A senator from a state in which a federal judge is to serve basically has an unofficial say whether a judicial nominee will be confirmed. Okay? I don't know how strongly that's being held to now. I tried to do some research on it and I couldn't really get a clear sense if it's as strongly applied as it was because the Senate's so divided. Judicial hearings, of course, are held. Senate judicial hearings are held to confirm a nominee where there are questions. And my wife and I were up in Nova Scotia a few years ago, and I'm trying to think of the justice, but it was do you remember which?
The man that wasn't in question.
Yeah, who was the high school drinker. What's his name? I'm not coming up with his name. Kavanaugh. Justice Kavanaugh the hearings were going on. So we walked into the reception desk in this hotel, and the receptionist is watching the hearings in Canada. Right? And she's like swearing at the television. And she turns around and says, "Oh, may I help you? I didn't see you." So we, give her our information. She goes, "Oh, you're from the United States." And we're like, yeah. But, and every time we walked into this Canadian hotel, there was a group of people watching the hearing. So, it's widely of wide interest. The litmus test, though denied by all presidents, litmus tests are used to determine if a potential nominee's philosophy is in line with presidential goals. Okay, so Democratic presidents prefer activist judges. Well, of course, Republicans prefer strict constructionists. Jurisdiction of the federal courts. In the US, we have a dual court system, one state and one federal system. We really have 50 state systems because each state has their own type of judiciary. Which complicates the task in determining which courts may hear various cases, okay? The Constitution specifically lists the kinds of cases that the Supreme Court can hear, okay? Now, most cases heard by the U.S. Supreme Court are on appeal. In other words, they come up from the district court or from the state Supreme Courts through the Circuit Court of Appeals, if it's from a federal district court, to the Supreme Court. They also hear, as I just said, state Supreme Court. We call them Massachusetts Supreme Judicial Court, which is our state Supreme Court. If there's a federal question involved in the case, then the case can go from the state directly to the Supreme Court, U.S. Supreme Court. The Supreme Court chooses which cases it wants to hear by granting a writ of certiorari, which means, it's a Latin word that means to be made certain. Certiorari is often granted on a new constitutional question or if two or more federal circuit courts of appeal have decided the same issue in different ways. Okay, so certiorari is basically saying, yes, we will hear your case. It's a big deal. They only hear about 100 cases a year. The Supreme Court has original jurisdiction in very few instances, okay, and only those named in the Constitution. So cases involving 2 or more states, cases between the United States and a state, and foreign ambassadors and other diplomats, and a state and a citizen of another state if begun by the state. Okay, I know that's confusing. Give you an example. When Massachusetts was suing the EPA, the federal EPA, because the EPA was ignoring the Clean Air Act, okay, which was causing global warming, which was causing melting of the glaciers, which was causing a rise in the sea, okay, and it was actually taking a land away from Massachusetts, okay. The Supreme Court heard that case because it was between a state and the federal government, okay? Okay, so just to make it a little easier to understand, the bottom is the U.S. district courts. Those are the courts where trials are held. There's 94 of them in 50 states. As I said, the U.S. district courts have original jurisdiction over most cases except where it's noted in the Constitution. The U.S. Court of Appeals, Circuit Court of Appeals, there's 11 of them, I had said, and they are only appellate courts. And they decide cases that come up through the district courts. So if you are convicted of something in a district court and you feel your rights have been denied you, you can go to the Court of Appeals, but it has to be accepted. And then the Supreme Court, there's only one, of course, and the Supreme Court has appellate jurisdiction through certiorari, which I'd said is like 99% of their cases. The process is limited in original jurisdiction, which I'd pointed out. Getting to court. Okay, so how do you get a case to the Supreme Court? It's difficult. 96% of applications are denied or rejected. The court cannot reach down. So if Congress passes a law, the court, they're sitting around, having coffee, the justices and say, that's not constitutional. They can't just say that law is unconstitutional. It has to come up through a case, okay? And then they, work its way through the system. Then they can grant certiorari and hear it. It's very expensive to hear a case. The actual cost is only $300 plus 40 copies, but then there's the legal fees and all the research and everything that goes behind it. Obtaining the records and documents can be very, very expensive. So the court can apply in forma pauperis, which arose from Gideon v. Wainwright, who was an indigent fellow, I believe it was in Texas, who was in prison, and he felt his rights had been denied, and he just scribbled it out on a piece of scrap paper and sent it to the court, and they looked at it and said, yeah, he's got a point here. And so now a court, the states have to provide a lawyer in criminal cases when a defendant cannot afford one. Special interest groups like the ACLU, the NAACP, the National Rifle Association, et cetera, will provide assistance in non-criminal cases quite often. You can find an organization that will help if you don't have the money. Legal terms, fee shifting, which is a rule that allows a plaintiff to recover costs from a defendant if the plaintiff wins. So if you're going after General Motors, and you're a dealer or an individual, and you win, the court can say, no, General Motors, you have to pay for all those costs this person went through. The plaintiff is the party that initiates a lawsuit. Standing. Now you hear this all the time, okay? And standing is a legal rule stating who has the authority to start a lawsuit, okay? So there must be an actual controversy between real adversaries. It's not like your 4-year-old child says, Dad, what if? Remember all those what if questions that they asked all the time from the back seat? So it has to be a real controversy that can be fixed, okay? You must show that you have been harmed, okay? It's not enough to dislike the government or a corporation or a union. You have to show actual harm. And the standing part is it can't be harm to somebody else but not you, okay? It has to actually be you that was harmed, or your business or whatever. Sovereign immunity. You cannot sue a government without its consent. This comes out of the 11th Amendment, actually, and it's more complicated than that, but we'll just leave it at that. And surprisingly enough, the states quite often will allow you to sue them, and the same with the federal government. Class action suit is a case brought to court by a person on behalf not only of him or herself, but of all other people in similar circumstances. In some of them, you have to be notified. All members have to be. I'm sure you've all received letters, right? My wife and I got one. I forget what it was about. And so we checked, yeah, we'll be part of it. So we got a check for like $5, like 2 years. No, it gets better. It gets better. It was like $5 2 years later. So we go, oh, we got $5 out of this thing. So we went and deposited. About a few days later, we get a notice in the Middlesex Savings Bank saying the time limit on that check had expired, and that's a $25 fee. So, and then we looked. I pulled out the envelope and everything, and the son of a guns sent the checks out after the check had expired. Okay, so I tried to call the judge up. You know how far I got with that. But, you know, so it cost me $20. So be careful with what you're... and then tobacco, asbestos, breast implant manufacturers are examples of companies that have had class action suits filed against them. Okay, Supreme Court in action. We're almost there, don't worry. We'll get to our discussion. The Supreme Court in action. The Supreme Court is in session for 36 weeks out of each year, from early October until the end of June. When they open the session, they have this thing called the Red Mass, right? Which is a Catholic religious service, a Mass. And our youngest daughter, Maggie, was in law school, and she was a first-year student, and it was the beginning of October, and she sent an email, said, I'm sitting here in a red dress in a Catholic Mass. Yes, hell has frozen over. So the 9 justices, with help from their clerks, and they have 4 or 5 clerks who are these, graduates of elite, top graduates of these law schools, read briefs in their individual offices, research case law, which I'll talk about in a minute, hear oral arguments, and discuss the decisions with one another in a conference room where no outsider is ever allowed. Once the case is granted certiorari, it takes 4 justices to grant certiorari. Yes, we will hear the case. It takes 5 justices to grant an injunction, which is an order to stop doing something or to hold doing something. I didn't go into those here because it was going to get too long, but I just wanted to mention it. And so once that's granted certiorari, the lawyers from each side submit briefs, and which is a written legal statement summarizing the case and lower court rulings and their argument. The oral arguments are presented by a lawyer in open court. Each side is usually limited to 30 minutes and speaks from a lectern with 2 lights. There's a white light that goes on when there's 5 minutes, we have 5 minutes to go, and when the red light shines, you stop talking. So if you are on the computer, Google Nina Totenberg, okay, who is an NPR journalist, I guess you would call her, but she's an expert on the Supreme Court, and she explains these Supreme Court cases. And this is on NPR radio, so you can listen to them, and they're just fabulous when she talks about these things. So the justices can and do interrupt at any time with questions. So sometimes, the lawyer will say, "May it please the court." That's how they start off, and a justice asks a question. Okay, these are not trials. These are just informational experiences for the lawyer to provide the justices with information, trying, of course, to get them to come to their side. Ruth Bader Ginsburg, when she was a lawyer, listen to those as well. Phenomenal, okay? In the federal government is a party, if the federal government is a party, not if there's a party in the federal government, which I'm sure there are plenty, but if it is a party to a case, either as a plaintiff or a defendant, which happens about 50% of the time actually, the Solicitor General represents the government. The Solicitor General is the third highest ranking person behind the Attorney General and the Assistant Attorney General. And they'll actually try the case, and they also decide what cases they're going to, defend on appeal, et cetera. Very important position. Supreme Court in action continued. In addition to the arguments made by lawyers, the amicus curiae or friend of the court briefs are often submitted. Usually these briefs are submitted by special interest groups or even by the government itself. Before such briefs can be filed, however, they have to either have both parties agree to it or the court itself has to agree to it. So it's just adding additional information. They don't come in and speak orally, they just submit the brief to the justices. Other sources of influence on the justices can come from legal periodicals such as the Harvard Review, the Yale Review, et cetera, which the justices and clerks consult, and citations from these journals often appear in decisions and opinions. Every Friday, the justices meet in the conference room and debate the cases they have heard. Before the meeting, many justices talk privately. I read the book in preparation for this by Jeffrey Toobin called The Nine, and it's really interesting because he goes in a lot into the interpersonal relationships between the various justices and how they try to convince each other, and will meet and they build these little teams for a particular case to be put forward. So they'll meet to try to gain support. The Chief Justice in the conference speaks first, followed by the other justices in the order of seniority. After the arguments, they vote in reverse order, with the Chief Justice voting last, so that the Chief Justice can have quite a bit of influence. He only has one vote, though. Okay, in deciding a case, a majority of justices must vote in agreement, and if there's a tie, the lower court decision stands. And you say, well, there's 9, how can there be a tie? If somebody's sick, or if somebody recuses themselves for some reason, if they have an involvement prior in the case, if they had been appointed and they had been a district or an appellate court justice. The decision of the court. So, though the vote is what really counts, the court traditionally issues a written statement or an opinion, they're called, explaining the decision. If the Chief Justice is in the majority, he either writes the majority opinion or appoints somebody in the majority to write it. If the chief is in the minority, then the senior justice on the minority side decides who will write the opinion. Justice Souter actually said, I just became the senior justice on the liberal side. I want that chance. I've been waiting all these years. I want that chance. You can't blame him. There are 4 types of opinions. Per curiam is a brief, unsigned court opinion. In 2016, there were 9 out of the 70 cases were actually per curiam. Typically, I read there's about 7% of the cases. These are on cases that are just limited to a particular issue, not one that's going to be widely used in case law, which again, I'll explain in a minute. Opinion of the court, a signed opinion of the majority. Concurring opinion, I agree with the majority, but for a different reason, and these are my reasons. And a dissent, and those are important because when we look at case law, and that is, we'll get to it in a minute, I'll explain it. That has an important part of that. Dissenting opinion are the people that vote against it. Okay, so if it's a 6-3 vote, the 3 justices will say, we disagree with this ruling because, okay, and they give their reasons. Now, in the opinion of a case, the justices can explain if the court's decision is narrow in scope, just pertaining to a particular case, okay? Or is it broadly going to be applied, okay? When we looked at Dredd versus Scott, the narrow opinion was Scott is still a slave, okay? Well, actually, it was broad, too, because it said that no African free or slave could be, or ever could be, is or ever could be a citizen. But then it went on to the, declaring the Compromise of 1820 unconstitutional. That was obviously a very broad case, okay? So that makes new case law. Okay, go on, next one. The power of the federal courts. The courts make policy whenever they reinterpret the law or the Constitution in significant ways, extend the reach of existing laws to cover matters not previously thought to be covered by them, or design remedies that involve judges acting in administrative or legislative ways. These actions have made federal courts very powerful, okay? Another measure of the Supreme Court's increase in power is how often it changes its mind. An informal rule of judicial decision-making has been stare decisis, meaning let the decision stand. And it sort of goes back to English common law that we talked about in that the first talk on the series I gave. Stare decisis is based on on precedents and is often referred to as case law. Okay, now case law is important. Okay, because in other cases, this ruling is going to be applied. Okay, now a couple of things. First, it's practical. If the law is predictable, then people will more easily understand if their actions are lawful or not. Okay, and we look as individuals and you say, well, it's pretty easy to know if you're breaking the law or not. But if it's a corporation, and what about tax law, it can get very complicated. So it helps these people to understand that. Second, the principle of equal justice, meaning similar cases should be decided in equal ways. Okay, so there's not one decision for rich people and one decision for poor people. However, times change and the court can make mistakes. Justice Felix Frankfurter once said, "Wisdom too often never comes, and so one ought not to reject it merely because it comes late." Okay, in other words, it's okay to change your mind. The court has overruled its own previous decisions in over 260 cases since 1810. Okay? Shanna? Oh, you did. I'm sorry. You're so fast. Political questions. Another measure of judicial power is the degree which the court decides issues that were once left to Congress. Okay, it's called a political question. In 1962, Baker v. Carr, the court decided that it was able to handle some political questions when it ruled on the size of Tennessee legislative districts. Okay, so I believe this case had to do with Nashville, Tennessee, which had grown to be a large city, okay? But it was actually underrepresented in Congress compared to some small, very small, almost villages that at one time in the 19th century had been important. So they brought a case and they said, no, one person, one vote. These districts have to be similar populations, and it gets all into gerrymandering and everything. It's very complicated. A remedy is a judicial order setting forth what must be done to correct a situation a judge believes to be wrong. So today, judges design remedies that go beyond simple justice for individual parties. Sometimes their decisions will impact thousands or millions of people. There was a case in Alabama where a prisoner sued the state for poor living conditions in his prison. The court found for the prisoner and ordered a $40 million revision of the court system in Alabama based on the Eighth Amendment, which prohibits cruel and unusual punishments. Okay, we all remember this one. In 1974, federal judge Arthur Garrity ruled in Morgan v. Hennigan that Boston must desegregate its schools. So he designed, implemented, and oversaw a school busing program, which of course caused all sorts of upheaval in Boston. The Supreme Court can refuse to hear a case. They can also remand or send the case back to a lower court with suggestions for a review, saying, we're not going to hear it, but think about this, okay? It's like when you're a teacher and you're correcting research papers. Think about this one, and hand it back. It'll make it better. Okay. Checks on judicial power. Judges are not immune to public opinion or the other views of government branches. The court does not have its own police power or army to carry out its decisions. Therefore, they do not make rulings that are extremely controversial, typically, to a large segment of a community or a nation. Okay, they're afraid that they're going to be ignored, basically. So they have to keep it somewhat within the bounds of what's thought to be acceptable. Now, reading the Bible in school or desegregation of schools were widely ignored, okay, by many towns and even states, all right? And it took a long time for it to get, in other cases, for it to be really implemented. Congressional checks on the judiciary, it can gradually alter the composition of the court by the kinds of appointments the Senate is willing to confirm, okay, and then we've talked about that already. It can impeach federal judges and justices. There's actually only been one impeachment of a Supreme Court justice. That was Samuel Chase in 1805, and the Senate did not convict him, so he was not removed from office. 15 federal judges have been impeached over all the years. Only 8 have been convicted, removing them from office. The last one was in 2010 when federal judge Porteous, who was a U.S. District Court judge from Louisiana, was convicted of accepting bribes and then lied about it. The first one was interesting. It was in New Hampshire, and it was for a federal district court judge. It was in 1803 for continually drinking on the bench. Okay. Congress can alter the number of judges though this gives a sitting president a lot of power. So Congress can make the Supreme Court larger or smaller. It originally was 6 justices. It went to 9, then it went to 7, and then, it went back to 6, then it went to 7, then back to 9. No, at one point it was 10. It changed 3 times between 1862 and I think like 1869, the size, and of course that was the radical Republicans versus the Southern Democrats, that whole issue. Congress can, and the states can amend the Constitution. The 13th, 14th, and 15th Amendments basically undid the Dred Scott decision. Congress can also undo a Supreme Court decision by making changes to a law the court has ruled unconstitutional. The executive can too. President George W. Bush, if you remember, on Guantanamo Bay and the right of habeas corpus for the people who were being held there, his branch made all these rules about those people not being able to have lawyers and stuff. And so it would go to the Supreme Court, and the Supreme Court, no, you can't do that, you change it again. No, you can't do that, you change it again, between federal courts and the Supreme Court. And Congress can change the jurisdiction or the types of cases a court can hear. The problem is if Congress takes away the jurisdiction on a particular issue from the Supreme Court, that would leave the lower courts with a free hand. An example of that, Congress actually did it during the Reconstruction period after the Civil War. It said the Supreme Court couldn't rule on government's decisions dealing with reconstructing the nation. Okay. And this is the last slide. And I just got it from the Gallup poll, and it's on the popularity of the Supreme Court. And so do you approve or disapprove of the way the Supreme Court is handling its job? The green line is approve, and the dark line is to disapprove. And you see currently it's 53 to 43%. Kind of interesting. A few places that changes over. I looked up 2016. Excuse me. Oh, that was bad. I apologize. That was with about the Affordable Care Act and things that were going on there. So that was, and there was something else too, I can't remember going on. It wasn't real clear cut to me, the reasons that I was trying to find, so I can't talk on it too much. But I just thought it was interesting that it tends to be a little bit more positive than negative approach. And it'll be interesting to see going on with this 6-3 balance, how that plays out. And our discussion questions. I want to thank you all for participating. You've been wonderful. And have a good summer, a safe summer. And I hope to see you back in the fall at some point, okay? Yeah, thank you so much. Thanks for coming. Yeah, I know. Yeah, maybe in September we'll get cookies.